Welcome back to Face the Jury. Today we have a very special guest, a friend of mine who comes to us from across the country up in the great northwest of Alaska. Meg Simonian, Margaret Simonian, everybody knows her as Meg, was nice enough to join us today and share with us some of her experiences trying cases in Alaska. I'm going to give a little bit of introduction to my friend before we get started. Uh, Meg is an attorney, a partner, named partner at the firm of Dillon, Finley, and Simonian PC in Anchorage, Alaska. She is widely considered to be one of Alaska's top trial lawyers who focuses primarily on medical malpractice as well as catastrophic injury cases. Meg has achieved some of the largest verdicts in Alaska history in both state and federal court. She is a native of Alaska, went to undergraduate at University of Alaska, and then went on to law school in the great Northeast and Northeastern University School of Law in Boston. She clerked at the Anchorage Superior Court. She worked as a public defender in the felony division. She has a wealth of trial experience, and I'm very pleased to welcome you, Meg, to Face the Jury. Thanks for being with us today.
Thanks for having me, Lloyd.
Well, this podcast came to mind. We met each other through the Inner Circle. Meg is a recent member of the Inner Circle, and we were talking probably at lunch or at some event, and we kind of gravitated toward the topic of jury selection, and it's an area that I know I'm always focused on and fascinated by people's different approaches. And one of the things and the reasons I am so excited to have you on the episode today is to talk about your perspective on jury selection and talk about some of the approaches that you use that have been so successful in your career. So before we do that, Meg, give us a little bit more about your background. Tell us the story of Meg.
No, the story of Meg. Well, I'm
Yes, the story of Meg.
born and raised in Anchorage, Alaska, which everybody, always elicits a, oh my gosh, it's a great way to introduce yourself to people. And I'm from a big family. I went to school out of state, came back. Anchorage, Alaska is a place of extremes. So we have extreme weather, we have extreme light, we have all these things that bring you close to danger and risk, but also the comforts of an actual city or town, and lots of wide open spaces. I have 5 kids, which also usually elicits a gasp. Sometimes and
What are the ages, Meg? What's the age range?
they range from 27 to 2 13-year-old twins.
Oh, wow.
So long span. I've been a mother as long. I had my first baby in law school, so I've been a mother as long as I've been a lawyer. So, and will inform everything I do, probably.
Of course, I hear 5 children. I'm thinking that's a perfect size for a focus group to present your cases and get feedback.
Right, it is, and it's a great focus group to try to make sure that you're simply describing your case and using non-medical terms.
Exactly. Well, tell us how you came to be a lawyer and go on that path, and particularly how you gravitated towards being a trial lawyer and working in medical malpractice. Not the easiest area to practice law.
Well, I always, oddly, neither of my parents graduated from high school. I always wanted to be a lawyer. Nobody in my family, I come from a big family, had gone to college. I just, from a young age, was told I should be a lawyer. So I don't know if that's because I was sassy or argumentative, but I've been people have told me that forever. So I thought, oh, maybe I should be a lawyer. And then when I thought I realized what a lawyer did, I just thought that's what I wanted to do. So I've been lucky enough, I think, to always want to do legal work. And then when you get a little closer to making that decision, I knew always I wanted to be in the courtroom. I just knew that. And I thought at first I was going to be a prosecutor. That was my plan. And then I went to law school and did internships at a prosecutor's office and at the public defender's office, and felt much more at home in the public defender's office, oddly. And I think that and I loved that work. It was such great work. I loved the camaraderie of it. I loved the pace of it, which is very rapid,
Hmm.
but it also was so challenging to leave the work in the office, and it was also so challenging with family. And so I decided to go into civil work, and I was lucky enough to work at Friedman, Rubin and White as an associate, not doing medical malpractice work, but doing mostly insurance bad faith work at that time, and completely, carrying senior attorneys' bags to the courtroom kind of thing. And then, but it was a
Very
great,
entry level, very entry
very
level.
entry
Yeah,
level,
sure.
and but it was great mentors
Yeah.
at that firm, including Jeff Rubin and Rick Friedman and Jim McComas, as a counsel, just like some of the best lawyers around in the
And what
country.
what a what a gift to be exposed to lawyers of that caliber and capability at such an early age, because you don't you sort of hit on it. You had more of a plan probably than I did coming along. I wasn't really sure what I wanted to do except the courtroom. I didn't know if that what context that would be, whether it's in the criminal system or civil system. But that's, yeah, that's your story sounds familiar. Not the five kids part, but the but the path that you've been on. Well, it's great that you could be here. And the topic today that I am really interested in exploring with you is the topic of jury selection, or voir dire, or voir dire, depending on what part of the country you live in. So for our listeners who may not be as familiar with that phrase and what it means, tell us what it means to you and how you approach jury selection.
Well, in Alaska, we say voir dire, and we are allowed to voir dire, at least in state court. As you know, in federal court, that's always a challenge. But what voir dire means is picking the jury. That's really what it means. And it's the only time in the trial process that, as a lawyer, you get to actually have a conversation with jurors and speak to them and talk to them and ask questions where they respond. So that's essentially what it is. Of course, it's like in trial practice, perhaps probably the most talked about, written about, and thought about aspect of the trial, because it's so critical.
And what's your approach? I mean, how do you prepare for jury selection? And then I want to talk about how you execute. How do you Um, obviously, you are very good at communicating and engaging, but I'm interested in your particular process.
So we in our state courts, we are able to get, well, before we even get to that stage, I always try to get the other side to agree to a jury questionnaire.
Why is that
And
important?
a jury questionnaire is important, and they do have to, in our system, they do fill out a very, very brief jury questionnaire that tells you, if they're married, how many kids they have, their job, sort of thing. But that's it. It's purely demographic. And an actual jury questionnaire that it would include some of the questions that might identify jurors who have a bias to either side is super important before you get there, because for two reasons. It can identify people who may not have a bias and who you don't want to spend a lot of time with, but that could be risky. But it definitely can sometimes help you identify people who you need to talk to, and who, based on the questionnaire alone, with juror research, which is the next process, can be the jurors you're afraid of, and that you definitely need to spend time talking to.
Well,
So
what you say afraid of? What do you mean? What jurors would cause you fear if they were to be seated as on your jury?
well, I think well, at least my perspective is, we want a fair jury. You want a fair fight. And so the jurors that you're afraid of are the people who have biases that can't give you that fair fight, no matter what you say. You know, we know from neuroscientific research that the way people make decisions is so much bigger and so less rational than we all think it is, that the judges and the jurors themselves are not aware of how much a bias can impact how they even hear the evidence around them. So that's the juror you're afraid of, is at least trying to find a person who has a bias, who is going to be impossible to convince, because they're only going to look at the evidence that supports their bias or their biased view.
Yeah, and that you're exactly right. And what you're saying resonates. And what I found too is that the word bias carries weight. So
Yeah.
we started avoiding that word because when people think of bias, their minds typically go to either racial bias or sex bias or some sort of
Yes.
one of a almost universally acknowledged bad thing. But every bias isn't bad.
No.
And tell us about that.
Well, and I agree with you totally using that word bias. And that's the problem with using a word like that is because nobody wants to be biased. Nobody wants to, and you're in a very unusual and uncomfortable situation of speaking publicly in front of a courtroom full of strangers is never going to want to admit to that. So I don't use that word either when I'm talking to the jurors, but it's just strongly held beliefs and opinions,
Hmm.
kind of the unconscious way we think about things. That's what I think you're looking to try to identify in people, even when they may not be aware of it themselves.
So let's get more specific if we can. So you're facing a jury trial in a medical malpractice case, for example. In your mind, do you have the perfect jury already selected as you go in, or are there certain traits you're looking for? There's certain characteristics. What is going through your mind as you decide who's going to be serving on this important trial?
I think it's dangerous to identify potentially good jurors based on the facts of your case or demographics alone. I think that's a dangerous thing to do because when you do that, you can miss people who appear on paper or on their social media, which is, isn't we definitely do that. Once we get the jury list, we spend time researching the jurors as much as we can. So we have a sense of what at least their public persona is. And you can have somebody who the public persona that you might think, oh, this is going to be a great juror. They they seem intelligent, they're open-minded, that sort of thing. And then it ends up they're not because they have some belief or opinion that's strong to them and their life experience that you can't see based on the demographics. But and it used to be, I think it's shifted some. It used to be like some people who had very strong political beliefs or appeared in some ways to be difficult to persuade in one direction or another on either side, extremely liberal or extremely conservative. Those, I think now I'm approaching jurors like that differently. It's,
What's changed? How are you approaching them now?
well, I think that there's definitely, especially after COVID, a more heightened suspicion towards hospitals, the medical practice, corporations, things like that from all sides in a way that is helpful to us. So you could have somebody who before might have seemed, closed-minded and not open and potentially like a tort reform type juror, somebody who doesn't think people should bring lawsuits or that money should compensate for losses in a situation where it's not hard economic damages. Those are jurors we're afraid of in our line of work. And before that alone would, you might have made assumptions about that type of belief from the way someone portrays themselves publicly on social media and things like that. But now I think there's also, while that still exists, there's also among that demographic of people a real distrust of corporations and doctors and hospitals, not just because of COVID, but just and because of personal of life experiences I think people are having in the medical care now that
Sure.
maybe this is too hopeful, shifting that tide a little bit. And it makes actually speaking to the juror and seeing how they respond to you important in a way that you can't make a predetermined idea like I want this kind of juror. Because if you come in with that, you could choose a juror that you don't spend time talking to who has a different perspective that you miss.
So do the rules where you practice, are you allowed a sort of a fulsome, robust process where you can spend some time with the individual jurors and delve into their backgrounds and try to understand their biases and their belief system? I mean, do you have that opportunity up in Alaska? Because we don't always in Georgia,
Right.
and some states don't allow jury selection at all.
At all.
Um,
And it's like in federal court, most federal courts are very limited in how they allow, and as the same as our federal court is here. But we do, I think we're probably in a spectrum of none. And then, there's also like Connecticut where you have individual voir dire of each juror and it takes 3 weeks to, it's incredible.
which makes my head
We're probably
spin
more
off
in
its
the middle.
shoulders to hear that. I can't
Yeah.
imagine 3 weeks to strike a jury. I mean, I don't. You probably know more about these jurors than you do your own family after you question them for
We
three
had a lot
weeks.
of time, I think. So we're kind of, I think, in the middle. It's
Yeah.
not extremely limited. It's not extremely permissive. They bring them up in a panel. They do, most judges, unless there's some sensitive issue, require you to address the panel sort of in the talk show host way where you're talking to everybody at the same time, and then let you or the attorney drive to asking specific questions or eliciting answers.
What is your preferred, if you had a magic wand and could do it the way you think would be most effective for your client, what's your preference?
I like having the group. I would not actually like having the individual voir dire of each individual juror because I think you're trying to build the group and build the cohesiveness of the jury in jury selection. And that's a super important thing in our successful verdicts is to have a group that is cohesive.
And do y'all have unanimous juries in Alaska?
No, it's 10 of 12. So we get that. That's good.
That is
And
really good.
it is, except in federal court.
Right, of course. Well, of course, in Georgia, we have unanimous 12, so we've got to get all 12 people on board. And, it's hard to get 12 people to agree to much in this world, particularly in the past few years. But so I want to see you in action a little bit. So I'm going to enroll you as a lawyer starting a trial, and I will pretend I'm one of the panel members on your jury, and give us an idea of. And let's just practice and some of the questions you might ask, and I might surprise you with some answers.
Okay, so from like assuming I've already done the introductory
Sure,
part of things.
that's right. I'm exactly. I'm Meg Simonian. I practice here. Introduce your clients. Sort of.
And one of the things that I always do with every panel is to elevate the service.
Tell us what you mean.
Well, I think the juries coming into a courtroom is one of the most incredible things about our democratic system because it's so rare that the strangers are brought together and empowered to do this important thing to our absolute strangers. And there's not that many opportunities in most communities to engage in that way. And in fact, I can't think of a parallel like it. So the whole process to me is just sort of, in a way, special and magical. But then the jurors hate it. They come in there, they're angry, they're frustrated, they're just tired of being made to wait. They don't want to be on the jury. So I feel like part of what I have to do in the beginning of every panel is make them understand how thankful I am that they're there and how special they are. Like the reluctant heroes, kind of.
And how important their service is.
Yes.
Yeah, sure.
And so I do that. I usually try to find out how many jurors were called and how many showed up. And so I tell them that at the beginning. I say, you are all special because you came, you showed up. And you're the one of 40% who showed up. 60% didn't. And this is an important case, and it's important to my client. And we appreciate that you're here, that you showed up. And what we're doing here today is trying to find, and I will say something too, I'll ask, why'd you show up?
Because I have a subpoena that says I will be arrested if I don't.
Right. And that's fair. But a lot of people got those and they didn't show up. So what was it about the subpoena that made you think this was something you had to do?
Well, what's behind that question, Meg? I've never heard that question before, but I like it. Tell
Because
me.
I'm trying to get people to say this is them to say this is important. And if I had an important matter that came to court, I would want people, responsible people like me, to show up.
Well, and that's I think that's so smart and useful, and it ties into um, to invite them to say or to ask them, say, well, this system depends on all of us. So
Yes.
if God forbid something happened to you or a family member where you needed to pursue justice through our courtroom system, people need to show up for you or you or you. And now you're starting to enlist the jurors and letting them see through the lens that people care the most about, which is, what's in it for me? How is this relevant to me? And I think what you're doing is so helpful to kind of get them to see it that way. Uh,
Yeah, and in the end, like in closing, I do spend always a significant, well, not significant, but a part of my closing is reminding them how important this is, what their job is, how important it is. And so, but in the beginning, it sort of just carries the theme through
yeah.
that and it also values them because I think they feel you want them to be comfortable enough to start telling you things. And I say that too. I say, my biggest fear here standing in front of you is that none of you are going to tell me anything, and this is my only time to talk to you, and I need to know these things, and I'm sorry that I have to ask you them in front of a courtroom of people with the judge with the black robe sitting up above you and a threat of subpoena if they said that. But I do because it's such an important job that we have a fair fight.
Well, anybody who knows you is very dubious that it would be hard for you to get people to talk to you in a jury selection process. I bet what I have found, and this is, I don't know if I'd be interested if this has been your experience as well, is how eager people are to talk about their experiences. We have all this anxiety of, well, if this question's too personal, let us know, and we'll ask it privately if you don't feel like addressing it. Sometimes jurors will have something they want to bring up privately, but 99% of the time they are open about traumas and they've experienced, really personal things and their health care they might share. I'm always shocked at how open people are. I think it's because people just want to be listened to and heard. I think this is an environment where that can take place.
Yeah, it's one of the only the uniqueness of the situation. I think is important to recognize because it gives them permission to, mostly you want to do that. I think give them permission to tell you things,
Hmm.
and I think you're right. I do think if you're the kind of person who can connect and communicate with someone, they will tell you things. But I've also been in situations with with opposing counsel when they're not as open with opposing counsel because I don't know that they're able to make that sort of connection, or they're just asking a question that doesn't ask for a real open response. It's more directed and scripted, kind of.
Yeah, and conditioning where they're trying to sort of advocate the case and get you to say
Yeah.
the right words and kind of lead you along. I my experience is, I'd be curious if yours is the same, is that the defense lawyers just do not prioritize jury selection the way plaintiffs lawyers do, because I think we understand that it's so important to seat a fair jury, an open-minded jury, because if you don't, it doesn't matter how good your case is or how talented you are as an
Yeah.
advocate, you're going nowhere if that jury doesn't have a buy-in and a commitment to being fair. Um,
I think that's definitely true there. It's a much less involved task for the defense counsel because I think they make some assumptions about people's views toward lawsuits and plaintiffs. They're in our line of practice, medical malpractice, their allegiance and loyalty to their doctors and hospitals. So I do think it is more that plaintiffs lawyers probably fret and worry and spend a significant amount of time preparing for jury selection in a way that defense lawyers don't.
So you mentioned that you try to elevate the process and help the jurors understand how important their service is. What else do you do that's uniquely Simonian in your jury
Well,
approach?
I don't think anything is uniquely Simonian because I've stolen everything I use. Everybody, like you, like Rick, like I mean, I read all of the Nick Rowley approach. I try to use some of that Nick Rowley approach, which is that the fair fight type uh type approach. And I think at the very beginning, we're both looking for a fair fight. There are people who have strongly held beliefs that doctors are trying to help people and they should never be brought into court because ultimately they didn't intentionally hurt anyone. Other people feel that doctors have a duty to their patients to be reasonably careful and use reasonably careful skills and assessments. And it is appropriate. We need to find people who have the middle ground, who aren't strong one side or the other, or biases one side or the other, not biases, but with strong opinions on either side, who are willing to listen and evaluate the evidence as it comes in without that filter. So we're
Well,
looking for a fair fight. And so sometimes I will try to elicit, does anybody here feel that have really strong opinions against doctors because of a personal experience? Like I try to elicit it.
mhm.
And then you can start talking to them about that. So you feel one way or the other. And then see if anybody raises their hands. I always raise my hand with them to try to get them to
Try to
do that.
lower the barriers a little bit.
Yeah.
We talked about how we're all, I wouldn't say stealing, but we are all being inspired by different
Yeah.
people who have different things to offer. Nick Rowley has made great contributions in this area. Sorry de la Motte is another one I know that we've talked about. And one thing that you're doing that I've heard Sorry talk about is providing context and explanation to the jury, so they're not just sitting there wondering why are they asking me all these questions. And it's so helpful if you can say, well, this is a case that involves claims of medical malpractice. So I need to spend some time and talk to you about your experiences with our healthcare system. I think context, which you do naturally, is so important because now they're starting to understand. But I used to in my younger career ask a lot of questions that I thought would give me great insight. What kind of bumper sticker do you have on your car? Where do you get your news? Which of course is code for, are you an MSNBC person or are you a Fox News person or something else? But to provide the context and so the jury starts understanding that what you're doing is important and relevant, breaks down a lot of that resistance, which I think is kind of what you're touching on.
They do, and it does that, and it also starts to help build your credibility, which of course is what we're trying to do all the time. And in almost every panel that I have done since I started using that method, I move for cause a juror who would be good for me. And
Tell me about that. Well, for our non-lawyer listeners, explain a few of these terms. You move for cause. What do you mean?
of course, so we have in Alaska, we have a 3 peremptory challenge rule, usually per defendant. And that, and the 3, that is, we get to pick 3 people we don't want and ask the judge to excuse them for any reason. But the judge has the duty to excuse a juror who has and doesn't meet the qualifications under the civil rules, which that's essentially says that they can be fair, to excuse them for cause. But it's asking the court to excuse a juror for cause is usually on the attorney who is doing the voir dire. Sometimes the judge will jump in if it's real obvious, but usually based on the questions that you ask with the juror, you can say to the judge, I'm going to move for, and ask that, Mr. Bell be thanked him for his service and ask that he be excused because of the statements he's made.
And
Now,
is that done in front of the jury? Do you have to?
it depends on the judge. It depends on the process. Sometimes it does, but when I'm doing that, I say it in front of the jury because what they're saying is I'm going to be biased for you, and I know that the defense isn't going to object, and it sets up this great construct, right, where I remove someone who's going to be biased from my client. They don't object, but then when it comes up later in the shoes on the defense's foot, they'll never do that. They won't.
It can be the most
They won't.
biased person in the world. Every
So I really don't. But I mean, I'm not going to be in front of the jury, trying to rehabilitate somebody who has been. That's not what I do. If somebody has expressed clear bias and not answered in a way that is meets the qualifications of a fair jury or a fair fight, then I'm not going to get up and try to rehabilitate them.
Well, and you're building your credibility up in front of the jury that you're fair and you're honest and you're
Yes.
decent, and you're not going to look for every advantage at the expense of your credibility. Because of course, we could have a whole podcast on the topic of credibility and how important it is. But it is if you do make a misstep or say something that undermines your credibility, you've really jeopardized your case.